cover some of both. Starting off with the Freedom of Information Act. Virginia Freedom of Information Act is a principal statute that governs both open records and open meetings. And I'm going to cover both of them. I'm going to give slightly shorter shrift to the open records part as opposed to meetings, because you probably have fewer meetings or fewer records issues, but I'm still going to cover it. But I just wanted to let you know I'm going to leave out the pieces that I normally would do in a training like this on treasurers and commissioners of revenue, who have some very special issues that just affect them, as well as some special stuff about law enforcement and fire EMS. Again, they have some very special rules that impact them that really just aren't particularly relevant to a BCA. I'm also going to touch on a couple of other statutes. The first one to know about is the Government Data Collection and Dissemination Practices Act. That has to do with how you manage electronic records, and I'm just very, very briefly going to touch on that in a couple of relevant places. Going to deal with the Public Records Act, which deals with how long and how you keep public records, and also when you destroy public records, because there are public records that you are required to destroy at certain intervals. And sometimes you destroy them just by throwing them in the circular file, and sometimes you have to shred them, and sometimes you can just throw them into the garbage bin on your desktop, and sometimes you have to actually go to the extra effort to really delete them. And finally, with respect to open meetings, I'm going to touch very briefly on the Americans with Disabilities Act and the First Amendment, both of which impact how you handle open meetings issues. To start off, at the very beginning, FOIA deals with public records, at least with respect to the public records part. So how do you know what a public record is? Well, public record is any information compiled in a tangible format. So that's not just paper, that's also emails, it's also databases potentially, it's electronic documents, including drafts. It's also at least potentially text messages, although for reasons that I will get to, typically FOIA requesters will sometimes request text messages, but due to the difficulty and consequent expense of pulling text messages, usually they ultimately say, yeah, sorry, never mind. How about you just give me the emails and that will be sufficient. That's how that tends to play out. But in theory, a text message would fall under FOIA if it deals with the transaction of public business. Transaction of public business is never defined in the law. It's a common sense standard. And it also might differ. Transaction of public business might be a different thing depending on who you are. So for instance,
sounds like American law.
How about a normative discussion?
Normative, what do you mean by
It
that?
means how it ought to be, not how, I mean, oh gee, there ought to be a law, or, this isn't, this isn't proper, or something like that. I mean, can we be critical of public business without actually being deemed to be transacting it?
You would, basically what you should be thinking of this as is any email that you send that has to do with the BZA or things potentially bearing on the BZA.
Right.
Should be the transaction of public business, even if you're saying, like in your example, the BZA should have a rule that says this. That is still transaction of public business. On the other hand, if you're talking about, let's say, the Department of Social Services,
Right.
BZA business has nothing to do with DSS,
Okay,
so it would be separate.
Outside of the exact precise nothing more than BZA business, we are allowed to comment on any public thing with First Amendment, full First Amendment privileges.
Correct. You have a First Amendment privilege There are some exceptions to that, and I can get into those later. But generally speaking, if you wanna go to the Board of Supervisors and comment on whatever, you have a First Amendment right to do so.
So, there's no distinction between substance and procedure in the email world?
Nope.
So if we wanna call, if we're sending emails to each other about a potential meeting, we can't do to all?
There is actually a fair amount of case law on that. So FOIA says that you can't have an all-electronic meeting except under certain very tightly defined circumstances, and I'll get to what those are. But you can only phone into a meeting or have an electronic meeting by whatever means under special circumstances. On the other hand, FOIA says that you're allowed to send letters and memoranda to each other, including to everybody. Third, FOIA says that you are allowed to contact other members of the BZA in order to ascertain their schedules or their positions on specific matters. How do you balance these three things?
Good question. You've already got us confused.
So typically, the way that you're going to balance those three considerations, if you're sending one sentence, my position is this, bam, that's probably starting to get into electronic meeting territory that you don't want to be in. If you are writing an email that says, or if you're writing an email that just says, is everyone available for a special meeting at thus and such date? That's probably okay. Even if people then say yes, 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 or yes, 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 no,
How
no,
can you
no.
only say probably? That must be okay. Can you see where I'm going with this? You can't tell us that we might get cited for arranging a meeting. You must know for sure.
And the short answer is that you don't know for sure until there's a case. You can only get so precise using words.
Okay, I understand it's an art, another science.
Well, and also you never know what a judge is gonna have for breakfast, and that might affect how he makes a decision. Generally speaking, if it looks like a letter, if your emails look like memoranda or letters, and they smell like memoranda or letters, and they quack like memoranda or letters, the court's going to say that's a memorandum or a letter. That might be a public document. Somebody might be able to make a FOIA request to look at it, but you're not on the wrong side of the electronic meeting rule.
Okay, so I can just rant about some issue before us and with no specific intent on asking anybody for the consensus or support, and I'm allowed to just go unhinged without anybody getting upset.
Well, they might get upset, but
No, I mean,
they,
I'm
not
not talking about
legally
me, but other
speaking.
people, you know, we may not always be the only ones here, so we have to think in the longer term, you know.
Ideally, what you would want to do is you would want to debate those substantive points in your actual meeting. That's not to say that if you have a whole bunch of stuff that you want to lay out, dear fellow members of the Board of Zoning Appeals, I think blah, 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 blah.
And I suggest such action as, boom, I'm out of it.
That's what I think. Signed, Bill.
Yeah. But if I do something like that, if I say at the end of it, this is my point of view, and I recommend this action, I'm violating the law, right?
You could say recommend, or you could say, this is what I think and what I plan to do when we actually have the meeting. You could say that.
Okay.
Of course, you can always change your mind when you get to the actual meeting.
Especially if you tell people in advance to get the feedback, you can probably guarantee
If people start responding to that,
You,
then you cross the line.
if people start sending
There's
out,
a time frame in there, right?
that's right. If people start sending back responses that are, 5-minute later response, no, that's wrong. That is a problem. You are getting into electronic meeting territory.
I see. So we just don't want to, we can make statements, we just don't want to correspond.
You can always correspond with one other person.
Okay.
Or if a certain, there's been a certain lapse of time, right?
Or, exactly, you have taken time to consider it like you would a letter or a memorandum and to compose a response in the same way that you would a letter or a memorandum.
So then this is like a day or an hour, a week, or just not immediately?
In the case that was decided, it was between 4 and 24 hours was the lapse between emails dealing with the subject, and the Supreme Court of Virginia said that that was not an electronic meeting.
Okay, so we just like put it off for a day.
Cooling off for a day is usually a good idea, because
Yeah,
the
well,
larger
now-
paper trail you have, the more things can go sideways potentially for you. As far as text messages, never text message more than one other member of the BZA once. Just don't send out to everybody, just send it to one other person. Another tip is don't send text messages to each other during a meeting. If you need to send a text message to your attorney, you need to send a text message to the zoning administrator in order to find out information so that you can make an intelligent comment. Very possible, right? Do not text message each other during a meeting. Outside of a meeting, only text message one other person on the BZA at a time. So now that we've already gone off track, but trying to get back to it, after you know what your universe of public records are, okay, the universe is anything recorded in a tangible medium relating to the transaction of public business. What is a FOIA request? How do you know when somebody has asked you for a document? In theory, anytime anybody asks a government official for a public record, they're making a FOIA request. They don't need to use the word FOIA. They don't need to do anything special. As a practical matter, you probably want to confirm with them, are you making a FOIA request? Because sometimes people pop off and you need to give them 5 minutes to relax and say, are you really making a FOIA request? And I'll send it along and get this process started, but really? Another thing to keep in mind is that you can require a person who is making a FOIA request to give you their name and contact information. That is for 2 very practical reasons. The first is that the Virginia Freedom of Information Act provides rights to Virginia citizens and media that broadcast or have substantial circulation in the Commonwealth of Virginia. It does not give rights to anybody to some lady from California who's trying to aggregate data and sell it. It does not give that person rights. It gives rights to Virginians. So you want to get that information so that you can confirm that that person is in fact a Virginian. Is affiliate, let's say the Washington Post, right? Washington Post is composed and published in Washington, D.C., or maybe suburban Maryland, not Virginia. But their circulation is so large that they're considered to be in Northern Virginia, even down to here probably, that they're considered to be a Virginia media outlet and therefore have FOIA rights. You do also want to make sure, and so you take down that information to make sure that they're a Virginian. The second, or a media representative. The second reason why you want to take down that information is so that you know where to send the documents to give a response. There is a little bit, and I'll give an example, there is a little bit of discretion to be used in there. Let's say that you get a request from the office of the law firm Troutman Pepper in Atlanta for a copy of your agenda for whatever meeting. Really, you're probably just going to respond, it's on the webpage here, here's the link, go find it. But let's say that you're in an ornery mood that day, and you figured, well, this person's from Georgia, I can just say no. Problem. Sharpton Pepper also has an office in Richmond. So if you say no, you're gonna get a call about 20 minutes later from an angry paralegal in the Richmond office. What did you just gain yourself? You still had to give the document, and now they're angry at you. You didn't gain yourself anything. So there's a little bit of discretion and common sense to be applied there. It's also important to make sure that you fully understand what the request is, and I'll get to more about how to do that. But I have the example of, I once had a situation where somebody made a request and they sent it in by email. We thought it was really broad. Produced 250 pages worth of documentation, charged them $45 for it. They said, we only wanted 5 pages of this, we're not paying any of this $45. And we said, yeah, you are, because if you look at this email, this looks like what you wanted. But you know what? That was a big fight, it was a political kerfuffle. They go to the Board of Supervisors meeting and complain about staff, hosing them. Staff didn't mean to do that. They didn't mean to ask for all of those documents. If somebody had a phone call or a conversation or made sure that they got it down 100% right, could have avoided a whole bunch of staff time that could have been better spent, as well as them being really annoyed.
Okay, the question on, because this is on who's filed or whatever.
Okay?
So the question is it, my understanding of FOIA, and most people are, it's for the public to be able to access the records of government entities.
Mm-hmm.
Is FOIA normally used within government entities as a process of getting information?
It depends. Ideally, my experience is that within a locality, within neighboring localities, you will usually just share information. Sometimes I've had situations where I needed to send a FOIA to a state agency because a state agency, like say DEQ or DHCD, was being particularly difficult and needed to raise at the level of making it a formal FOIA request. This example is when I'm representing a county or a city or a town or a water authority or something. That's mainly what I do. But it would be unusual to see that happen within organizations, certainly of the same locality.
So, but it's permissible but unusual for the county to FOIA the BZA.
It would be unusual. Typically what you would see instead is you'd see some county administrator or somebody give a call to the chair and say, hey, I need these papers. When can you get them to me? Oh, I'll get them to you next week. Okay. Or, no, I really need them tomorrow because I'm trying to get out the board package and I need that information. All right, well, I'll get myself onto the computer tonight and send it over to you. That would be the way you would typically handle that.
Right.
Okay, what about then if within the organization, one person in the organization chooses to charge another person in the organization, who pays the bill?
That's complicated.
Isn't it?
If it's, let's say that it's just for example, let's say that the Board of Supervisors decides that they want to know more about the rate setting model for the service authority. They say, the rates are too high, we want to know why they're set where they are, we want to know more about the model. They call up the service authority, the county administrator calls up the executive director of the service authority. Executive director says, I'm not giving you those documents, go fly a kite. Okay. County administrator sends a FOIA request to the service authority. Service authority decides that they're going to charge. Okay. Because they probably do have to give all that information. There are exceptions, but probably. The county, ultimately the Board of Supervisors gets to decide whether that's going to be paid for by the county out of county funds, or whether it's going to be the Board of Supervisors is gonna say, well, County Administrator, you were on your own. Hope you, go find your checkbook. That's ultimately up to the governing body of whatever individual entity. And you guys know, although in the minds of the public, the county's sort of one monolithic organization. In fact, you have several different entities. You have a Board of Supervisors, which is independent, a BZA, which is semi-independent, constitutional officers, each of whom is semi-independent, a service authority that's semi-independent. Each of them is a separate legal entity that has a lot of autonomy from the others. But you do have to, at some point, play nice together.
It shouldn't be your first choice on trying to get information.
No, at least within the organization. You know, if somebody has an appeal before you, and they might FOIA you, and you might have to give it to them, but that's a whole different matter. At that point, you're in a much more formal relationship than you ought to be having on a day-to-day basis with other entities within the same local government. In any event, when you get a FOIA request, you do have to respond. You have, written down here, you have 5 principal responses that you can give. First response is, unless it's something super easy. So let's say somebody asks for the agenda for the next meeting. Send them a link to the agenda page on the internet, all done. Thank you, my life, that job's over, that was easy. But a lot of times, somebody's asking for a more involved set of documents that somebody's gonna have to spend time finding. Somebody's gonna have to spend some time on it. Your first thing that you always wanna do is, in that situation, is tell them, there might be a charge for this. Are you still okay with my moving forward? Now, if they take time, then you just wait and don't start doing work until they've given you the go. Your response is always, your first response is always going to be due within 5 business days after the day that you receive the request. Day 1 is the day after you receive the request. So it's not the day of the request, it's the day after. Note that if it comes in after close of business of one day, day 1 is actually 2 days out because it's after 5 o'clock. Let's say that you got it at 5:15 today, that would be counted as having been received tomorrow, which means day 1 would actually be Friday. And then it's 5 business days, so if there's a holiday or whatever in there, that doesn't count as against the 5 business days. I do know of one very small town that got a FOIA request, and their town office was only open 3 days a week, and there was a holiday in the middle, so they said that the 5 business days actually took 2 weeks to go by. That resulted in a kind of a kerfuffle in the local paper, so I'm not sure that was the right way to have gone, but that was the way they went. They didn't get sued, but there was a kerfuffle in the paper.
Okay, and the time, I just quickly, the time, how do you calculate the expense for the time? Lawyer's rates?
I will get to how you calculate that. That's actually the next slide. Do you want to hold it or do you want me to? Okay. If the response to something is going to be large or difficult to pull together, you can always send a 7-day letter. It's called a 7-day letter. It says, I'm going to take another 7 business days in order to respond. Okay, beyond your initial 5 business days. If it's still not going to be finished, you want to try to agree with the other party. Hey, look, you asked for the emails from 12 county employees who each sender receive at least 50 emails a day over a 2-month period. Guess what? That's going to take forever for us to go through and pull all of those. And people never understand that when you have that many emails, well, I just want the ones that have to do with thus and such project. If it's a major rezoning, that could easily be, just to pull using keywords, that could be 50,000 emails that somebody needs to go through, pull out the emails that aren't relevant, figure out which emails are between the planning director and Art Goff, because if it's with Art, it's attorney-client privilege, figure out which ones are otherwise privileged, it becomes a huge task. This happens. I once had a situation where a city and a water authority were getting ready to go to war with each other over service territory. We each produced well over 100,000 documents to each other. We agreed to give each other a little over 2 months to pull all that together. I actually once had somebody who refused to give us extra time, so I actually had to go to court and get the general district court judge to say, yeah, you can have an extra 45 days. When he saw what it was, I just had the person who had to pull it testify how much he did and how they went through the process, and the judge was like, what? He looked at the person who was fighting me to give time, and was like, what is wrong with you? This isn't that important.
So question, to make a broad sweeping kind of FOIA request like that, do you have to have some standing other than just pure curiosity, or
Nope,
you don't?
you can't ask them why.
Got it,
If you want the paper, here's the paper.
got it.
Your other responses that you can give are, we don't have any documents, although if you know that somebody else does, you have to, or think strongly that somebody else does, you have to say. So if somebody sends a FOIA request to county administration, says, we would like to know the list of all delinquent real estate taxpayers. That's a public document, actually. But the county probably doesn't have it. Probably the treasurer has it. So the county would say, we don't have any documents responsive to this, but we believe the treasurer may. Here's the telephone number and email address for the treasurer. If all of the documents are exempt from FOIA, then you need to say, all of the documents are exempt. Now I get to exemptions. All of the documents are exempt, and here's why, and how many documents are exempt. So you might say, 24 emails exempt due to attorney-client privilege. 15 emails exempt due to the fact that they concern a report from a consultant about about terrorist preparedness, let's just say. That's another exemption that exists. So you need to say what those are and how many documents there are. As I will get to, if you have a document, let's say you have a giant email chain, and 2 of the emails in there are attorney-client privileged and the rest aren't, you need to redact the piece that is exempt from FOIA and produce the rest. So that actually can take some time, which leads me to the next.
What about working documents?
Or
is that coming up?
I will get to that.
Okay.
The next issue is, it may shock you to find out that most government entities do not have people sitting around waiting to respond to FOIA requests. I think that probably the taxpayers of Rappahannock County would lose their minds if somebody was being paid to sit around county administration waiting to respond to FOIA requests. So, as a matter of fairness, people are asked to pay some amount as a way for the local government to recover some of the costs that they are putting into responding to a FOIA request. You can charge, and as a public body, you can charge actual out-of-pocket costs. So let's say that they want it in paper format and your copier vendor charges 13 cents a page for copies. All right, well, 13 cents a page written in there. You also always have to take into account the salary of whoever it is who searched for the documents and did the copying, because that can be pretty substantial, as well as the person who did the review or the redacting, and potentially also the amount paid to an attorney, like the county attorney or me, or the attorney for the service authority, let's say, who might have to answer a couple of very tough, close call questions and do a little bit of research. So, can recover the salary, but not the benefits of the people who do the copying or the searching. You should have it be a person who is relatively low on the totem pole as possible. Now, there are going to be some documents where, guess what? Gary Curry needs to be the person who finds it, because it happens to be just something that he's the only person in the organization who knows it. More often, you'll be able to push that to somebody lower. If something is just making copies, you probably want to have your desk receptionist doing it at, $18 an hour rather than Gary at, whatever, $45 or $50 an hour.
75.
Okay. But who's counting? That would be,
Now, do they have any right to be able to delegate that to people who are not paid and say that it's free? I think how we see that happen.
if you can pull that off,
You're doing it, yeah. you say-
then good for you, but that would be unusual.
Yes.
Yeah, well, actually, that is a good question, isn't it? BZA,
Uh-huh.
now, if we get $30 a meeting, so you turn that into an annual salary, and then take it back down to an hourly rate, and it's probably maybe 15 cents an hour if it's that much. And we are required to spend a lot of time doing that. Is that what we charge 15 cents an hour?
Again, my experience is that usually the zoning administrator is designated as the official clerk of the documents of the BZA. And there will be somebody in the zoning office who is actually the low-level secretary who answers phone calls, and that person will actually know where most of the documents are. And that person's salary will be the one that gets paid.
Well, welcome to Rappahannock. Because it ain't that way here.
Well, then you might have to handle it other ways. And you might have to do it yourself.
This is a really fine point that we're facing. Could
Yeah.
you just repeat what you just said really clearly so I can write this down?
Most normally, the zoning administrator is going to be secretary of the BZA. Now, I'm going to get to some of the limitations on things that you can talk about with the zoning administrator. That's going to be the second half of this presentation. However, just to hold paper, just to
Keep records.
just to keep records. Again, there's usually, I'm just guessing that probably your zoning administrator and county administrator have a admin in their office. That admin can probably take care of the records. That would be the
You mean
normal
an
way.
administrative assistant?
Yes.
No, that's the larger counties. Which is, we may need one though, really seriously, because there's some kind of concern whether we're overloading our zoning administrator with these menial clerical tasks, which might be better done by someone else, but, I don't think that we're qualified or ought to be relative.
You might,
Really our purview?
you might have to do the searches as a practical matter, because there's
We might
nobody
have
else
to do what?
do searches for documents as a practical matter, because there's nobody else to do it
We, the members of
as
the,
of the BZA.
And if we don't do this, we're guilty of a FOIA violation, which is $500 for the first offense and up to $2,000 thereafter, correct?
If it's willful.
Well, if it's willful, if they tell us we have to do these things and we say, no, that's willful as
That
you get,
is
so they're gonna,
willful.
so
If
you're gonna pay
if-
this person who is our keeping our notes at $150 a week. If they stumble or fall, they get to be charged $500 to $2,000 in infraction every time they screw up?
No, if you stumble
I
and
mean, that's what
fall,
it says.
if you stumble and fall, if you just happen to.
No, okay, let's say that you say, no, we're not gonna do, this is
Then
not,
that would
we
be
did not
wrong.
volunteer to take, we are not the apprentices or the assistants or the administrative assistants of the zoning administrator, and this is not our job. And we volunteered to do something, but we did not sign up for menial clerical duties.
You might
And
have.
we're not advancing menial clerical duties were part of the job description here. We need job descriptions for a lot of things. And it might, one of them might be what we are expected, or what is expected of us as
I think that
BCA
would be
people.
up to the
Most of that is
chair.
just
I
kind of
think that would be up to
understood.
the chair to define that. Can we not hijack this training,
Well,
Mr.
can-
Walker?
well, I don't know what you're talking about. Can you,
Not unusual.
What, again, what I would suggest that you have is work out a deal with the zoning administrator and the county administrator to have some type of secretarial help to hold on to those documents for you so that you are not doing it except in the odd circumstance where,
we don't
say
have-
somebody asks for Bill, I wanna look at Bill's emails relating to this application. You might still have to go through your own email.
Oh, that's
be
not a
the
problem. I used to
person
work
who
at the White
does
House,
it.
we get that stuff all the time. You know,
Right.
You just like, everything is related to Bubba.
Right.
That's not
But-
what I'm talking about. I'm talking about reviewing these emails and checking for client privileges and rejecting those. And there's a lot of work, clerical, work being required here, and we wanna know if we're gonna be paid 50 cents an hour enforced by law to do this, or if we're gonna be able to charge what we would normally charge in our day jobs.
And you probably would have to, my recollection is that the county board of supervisors gets to decide what your compensation is. So they could set a reasonable compensation.
Well, they have set compensation as what is far from reasonable, and especially since now they're trying to unload all these other duties on us besides what our normal duties are. I mean, they've suggested that it's up to us to notify the newspapers, it's up to us to do all the.
You know, we feel, there are resolutions to that issue, and that we don't need to discuss it.
Oh, okay, all right, well, we'll pass on that then.
So that leads to the question of the FOIA officer. State law requires every public body, and you are a public body, to designate a FOIA officer. That FOIA officer does not need to be a member or employee of the public body, although they can be. I know constitutional officers will oftentimes designate themselves, even though one locality I know, the city manager was like, yeah, you can just use my secretary, and the constitutional officers were like, no, we're separate. We're not gonna use your secretary, to which the city manager said, oh, okay, if that's what makes you happy. But more to the point, every public body needs to have a FOIA officer. That FOIA officer needs to be registered with the state Freedom of Information Advisory Council, and that person needs to have training once a year on how Freedom of Information Act works.
Does this qualify?
What's that?
Does this qualify?
It will if you wanted to. I can send you a
That would be
certificate,
nice,
and then
because
you would have a
we
certificate.
have a FOIA elected officer who's in requested training, and it would be nice if that could save them.
Actually, if we're all sitting here at the table, then we all get a certificate.
If that's what you'd like.
That way, the FOIA officer can change on an annual basis, but to do what we did, because we had no choice, is to appoint a person who didn't have FOIA training to be the FOIA officer, because, particularly with the pandemic, that sort of fell by the wayside anyways.
Sure.
So that way, the board is, prepared.
What's the agency that you need to register?
Registered.
You got it, I'm just curious.
It's called the Freedom of Information Advisory Council.
In Richmond.
And actually, they will answer FOIA questions for you if you're confused about something.
Great.
If something is in or close to litigation, they typically won't touch it. But if you're asking an actual question rather than doing a gotcha, then they will answer the question and try to help.
Okay, great.
Okay, then the next question that comes along with this is, who provides the training?
It can be either the Freedom of Information Advisory Council, or it can be your local government attorney. So if either our GOF or I gives you a training, then that would count, as well as if you watched the webinar or went to, both VACO and VML have the FOIA Council people come out and do a training at their conferences. There are several opportunities out there if you want to do.
Do most localities tend to sort of, which we did here at one point in time, have an annual sort of training session or whatever for, various FOIA people within the organization to attend?
Localities that I represent and authorities and whatnot that I represent, yes, I do those trainings for them annually. Oftentimes I'll just invite everybody I represent to just come sit in a conference room at my office and I'll do it to get it over with. People that have full-time in-house county attorneys, usually their office will provide for it.
Actually, the state office had been coming here in the past, but
Yeah.
that's sort of up by the wayside.
So the FOIA officer, a lot of it is very standard stuff, common sense stuff. Whichever one of you gets the request, you send it to the FOIA officer. FOIA officer says, all right, well, I guess I better reach out to this person and find out what it is that they want. Make sure I've got their address down right, make sure I know actually what they really want so I don't give them 200 pages when they only want 20. Figure all of that stuff out. Write down on the calendar and make sure everybody who needs to know knows how long it is that you have to actually give the response. Contact the relevant people. Pull together the documents. If the documents need to be redacted, or you need to withhold them and figure out what exclusions are applicable, you go through that exercise. If you need to reach out to your attorney on complex issues of interpretation, you do that. Leads me back to something, I'll get to it, come back to it in a second. And finally produces the documents and gives the response to the requester. One thing that I wanted to circle back to, if the response to a FOIA request is going to exceed $200, the cost for you to respond, you can ask somebody to make a deposit. And as for attorney time, you cannot charge for time that an attorney spends just re-reviewing documents. But if you have an issue of interpretation, you're like, I have this email between me and the zoning administrator and the county attorney is on it. Let's say this is dealing with an SUP where the zoning administrator actually is on your team. And it also has our golf on it, but I really can't decide. I just can't decide whether that's privileged or not. Well, you might need an attorney to take and spend 20 minutes looking at that, scratching his or her head and give you the answer. And you can charge for that 20-minute legal fee, that's kosher. But you can't charge to have the attorney just go over and quality control your work.
Okay, on responding when a FOIA request comes in and it goes out to the members or whatever, the members should not individually respond to the person that is requesting the information. Is that correct?
They should respond to
Only to him.
the FOIA officer, and then the FOIA officer gives one centralized response. Another important thing to recall, and I'll get to this again, is that a FOIA request is a request for a document. It is not a question. If somebody asks you a question, then that you might decide that you want to answer it as a good public servant, but FOIA doesn't require you to do so. A FOIA request is always a request for information that is contained in a tangible medium, not a question of, what do you think about this? Well, if that's not written down anywhere, then you don't have to answer. I mean, again, you might give them a call and say, let's chat about this issue, but that's a totally different situation from a FOIA request.
And another one, what about incomplete documents?
Incomplete documents are still producible. Yep, those are still subject to FOIA, even incomplete documents, drafts. So the next question is, what about sensitive documents? always remember that FOIA is going to be construed by a court in favor of disclosure and against exclusions. There have been some exceptions to that over the years, but it's always been situations where the facts really were ugly. And if part of the document is subject to an exclusion but some not, then you have to redact it. And that became written into law a few years ago, and I want to mention to you this case so that you understand how generally FOIA is construed in favor of disclosure, but sometimes you'll have very special facts. This was a situation in which a sheriff's office was investigating a suicide. And they wanted to withhold the suicide note, which said all sorts of awful things that the family really, really, really didn't want to have public. And so the sheriff's office said, we're just going to withhold the whole thing. We're not going to redact this thing. This is this gives away certain information about X, Y, and Z things that are exempt from FOIA, and we could go through and blackline it, but we're not gonna. The Circuit Court, and ultimately the Supreme Court of Virginia said, yeah, we're not gonna make you give any of that out. That was one of those situations where a court probably actually said something that the General Assembly didn't have in mind, because the facts were just such that it needed to be that way. But subsequently the General Assembly said, oh no, we intended for you to redact documents. But they also put in an exemption that you can use to avoid handing out a suicide note in that situation. So they really resolved the issue. I'm going to circle back to this slide on the website and go to the commonly used record exclusions. And I have probably the 6 that are the most common. There are something like 140 FOIA exemptions in the statute. Most of them, however, are things like proprietary financial information not subject to SEC disclosure provided by a prospective lessee to the Virginia Port Authority pursuant to renting a wharf. You know, it's like, that's going to apply once every 10 years. There is the ones that come up to it most commonly with a county, and not all of these are applicable to a BZA necessarily, but that are going to come up in the routine everyday work of a county. Personnel information. So the information that's in somebody's personnel file that you would expect to be private information. Now the county always needs to disclose the names, positions, and salary and reimbursements of any employee who makes more than $10,000 a year. But a lot of other stuff is considered to be personnel information that doesn't have to be disclosed. Work product or memoranda of legal counsel or attorney-client privilege communications. Proprietary information or trade secrets provided by an economic development prospect who's under an NDA. Probably doesn't come up often for a BZA, but general knowledge, you guys see things going on with the Board of Supervisors or the Economic Development Authority, sometimes it will fall into that. Confidential information relating to a public contract, oftentimes is exempt. Executive working papers. I think that you could make a strong argument that the personal notes of the chair of the BZA are exempt. Just the personal notes, not everything, but if...
What about the personal notes of the rest of us?
You guys would not be the chief. I know that sounds weird.
Say this again, I'm hard of hearing. What?
Executive working papers.
But so, since we're not executives, anything we write...
So like all these little notes here, cool, yeah.
Although if you're writing down notes about things that you want to ask your attorney afterwards, that might be attorney-client privilege.
So anything I've written down here, somebody can ask me to see that.
Maybe, depends on what you wrote down, but yeah.
Well, they don't know until they see, so they can ask to see if it's, they have access to anything, right?
Potentially, yeah. Pays to have good memory.
What?
It pays to have good memory.
Yeah, I'm gonna stop taking notes. I'm not gonna take any notes.
What about personnel information that person who is the personnel wants access to their, does FOIA cover access to your own personnel information?
You always have access to your own personal information.
Or not.
A FOIA does not exempt it from yourself. All right, so I do have the slide in here for treasurers and commissioners of the revenue, but let's just skip that because it doesn't matter that much.
I have a question real quick. I make notes periodically on my computer of things, when I see something that's not really right in the way things, the process is working.
Mhm.
I write myself like suggested kind of legislative suggestions.
Mhm.
Okay, these are just, I've never shown them to anybody, I just say like, well, we came up to this case where such and such was a problem and we weren't able to resolve it, but if we had an ordinance that said thus and such, that would be easily resolvable every time, and but now they get to see that? Because I mean, it's directly, specifically related to this, but it's also my personal notes, and I'm not the executive.
Right. How long do you keep that?
How long do I keep it?
Yeah.
Definitely, I never erase anything intentionally. It gets erased on, I'm not saying it doesn't go, but
Right.
not intentionally.
Because those type of personal notes, you only need to keep those as long as they're what's called, under the Public Records Act. Under FOIA, you might have to produce it. Under the Public Records Act, you probably don't have to have it. So, if you don't, so you can get rid of it as soon as you don't no longer consider it to be useful.
Well, I spent a
And
lot
so
of
that
time
would be
working
my
out the
suggestion.
phraseology and the wording, so I don't wanna get rid of it, because if that ever comes up, and sometime I'm hoping it will,
Mm-hmm.
you know, these are problems, and someday we may be able to sort them out, and if I can go to my notes, even if it's, you know, people have been on this board for 20 years, you know, I could go back in 20 years ago, oh yeah, well, we got this problem back then, I thought this, maybe we should consider that, and I mean, I spend a lot of time crafting these pieces, I'm not getting rid of them.
Right. Somebody could potentially ask for that. The likelihood of somebody knowing that you have that, and asking you specifically for it, is very low.
Big trouble, no, he's
I know
in
they
the
can.
paper tomorrow.
As a practical matter, it's very unusual for somebody to actually successfully ask for that, because nobody knows that you've got it.
Yeah, well, I just know the things. Anyway, okay, yeah, that, in the future, we'll.
Final points to keep in mind is that for the longest time, we would go and have the mantra, FOIA never requires you to create a new document. It's not 100% true anymore. If you have and this probably won't apply to you guys, but if there's information in a database that can be pulled using a routine report, then you have to pull it using the routine report. Again, probably doesn't apply to you, typically would apply to somebody like, whoever is in charge of personnel for the county, that might come up for if they're pulling something from the HR records. Or if somebody asks for the list of all the meters that the service authority has, that's, I'm sure there's no actual paper list of that, it's a database. Incidentally, with respect to those, the service authority does have to produce the meter numbers and the amount charged for each meter, but they do not have to tell you the name attached to that meter. So, these are the things that you learn if you do this for long
You can
enough.
request that though, right?
They usually don't request it under FOIA.
No.
They usually get a search warrant.
Right, exactly.
So, switching over to public meetings. Anytime 3 or more members of a public body are in the same place discussing public business, or even electronically discussing public business, that's a meeting. Now, just because all 5 of you happen to wind up having cocktails at the inn and you're talking about how you're so darn glad that Dan Snyder finally sold the Commanders, that's fine. That's completely kosher. Wonderful. But if you start talking about that variance application that's before you next week, you've got a problem. So, pay attention. It's up to you to police yourself and have good FOIA hygiene, as I like to say.
It would be somewhat suspect if you were all sitting at the same table at the end, correct?
Somebody may go over and start listening in from the newspaper. That would not be shocking. But I've seen 3 supervisors be sitting at a table and they're talking about the ag fair down in Carroll County. And it's like, well, that's not public business. You're just talking about going down and looking at the cattle. Okay, that's whatever. Nothing wrong there. In order to have a meeting, you need to give appropriate notice. And typically, that's going to mean giving notice on the local government website, in another prominent location, such as the front of the courthouse, and in the office of the clerk or secretary of the body.
Okay, question on that one.
Yep.
Usually in front of the courthouse. Now, if your meeting place is in the courthouse, but you need to have one of those quick meetings that sometimes you have to have or whatever, can you do that on the steps of the courthouse, or do you have to actually be up in the room itself where the meeting is normally held?
It depends on what the notice says. If the notice says it will be in the circuit courtroom, then you gotta be in the circuit courtroom. If it says it will be at the circuit courthouse at thus and such address, then probably having it in the vestibule is just fine.
Okay, because we went through that, remember? So we wanted to do it the easy way, but we had to actually open up the building and
But it
go
needs to
inside
be in
for
all
2
3
minutes.
places.
And that's something that I wanna say that went into law 3 or 4 years ago. It used to be that you just needed to post at one place, which could either be the courthouse or the chief administrator, but now you gotta have it all 3 places.
Okay, question, in the office of the clerk or secretary, it kind of doesn't really apply here, but would it be in the zoning administrator or the county?
That would probably count. Again, if you can make a deal with the zoning administrator to help you, that would be very helpful. But if not, probably leaving it in that office would be sufficient.
Okay.
Well, I've been here 30 years, I just found the bulletin board in the courthouse the other day that has all that stuff on it. Never had a clue it was there.
It's still a prominent public place,
Oh, it is.
as
yes.
much as there is one.
Yes, but that means the point is that how many people ever go over there and read that stuff? And there was, I mean, it's a small bulletin board that is so loaded up. that, But it's all posted.
Mhm. You need to, go ahead,
In the
sorry.
office of the clerk or the secretary, which clerk and which secretary are we referring to?
The clerk or secretary of the body.
So the zoning
Oh.
administrator.
This would be the zoning administrator.
As a practical matter, it would be the office of the zoning administrator. Not like pinned on the front door of your house. You need to give notice of emergency, special, and continued meetings as well, using that same notice process. You need to give it at least 3 business days in advance. And that, just to have a meeting, you need to have a notice. If the meeting has an agenda, you need to post that, you need to make it available to the public simultaneously with providing it to members. Posting it on the website tends to work pretty well. Somebody does have, go ahead, sorry.
What's a meeting without an agenda? Is there such a thing? I mean, I'm just,
A quick meeting.
yeah, but that has an agenda, obviously, doesn't it? I mean, why would you have a meeting without an agenda? I'm not
Sometimes
sure.
advisory boards will just say, we're going to have a meeting, and then you'll just adjourn, and that will be that. For a BZA, it would be difficult to imagine a situation where you did not have at least some type of agenda.
Right,
I have a question on this. This is a point that's not really been clear to me.
Okay.
We here use board docs. If we do a procedural change, or our minutes or whatever, if they're not posted in board docs, they're not, are they or aren't they effective?
If
They've
you,
not been posted publicly.
you do not need to post something publicly in order for it to continue to be effective. At a regular meeting of a body such as the BZA, any matter that can lawfully come before them can be brought up. Special meetings are different. Special meetings, the notice has to say what you're gonna talk about. But just because you have an advertised agenda for a regular BZA meeting, your regular, was it fourth Wednesday? It's today, right?
That's it?
Just if you have a regular, so this special meeting, all we can really do is training, because that's what
Right.
the notice said. But tonight, you're gonna have a regular meeting,
Right.
which means that you can bring up kind of anything that would be lawfully in order, even if it was not advertised as part of the agenda originally. So if somebody says, I move to amend the agenda to add X at the end of the agenda.
I
You can do that.
understand that. My question is, what about in the interval between when the decision is made and when the meeting happens? Like,
How is that, how would the decision be made prior
Decisions,
to the meeting, because you would have to have a meeting to make the decision.
okay, so
decisions can
I
only
know
get
I don't
made
wanna
at
get into
meetings.
the specifics here, but if you have a change in a document and it just kinda hangs out there and doesn't go anywhere, and then your meeting is 2 weeks later, in that interval, does that, change have standing, validity, whatever?
You can only take actions at meetings of the body. So if somebody suggests a change, let's say, to a previous action, it would need to get brought up at the subsequent meeting, and then you would need to take, depending on how the action was set up, under Robert's Rules of Order, you could have a motion to rescind the previous action. And that motion to rescind would allow you to retract the previous action and change it. Now, the funny thing about a motion to rescind is that if anybody has taken any action in reliance upon the previous action, a motion to rescind is not in order. So let's say that the Board of Supervisors passes it approves a contract to buy an F-150 for the Public Works Department. But the county administrator has an inkling in his mind that it's quite possible that this deal ain't gonna go anywhere, and that the Board of Supervisors isn't really in favor of this deal. So he sits on signing the contract until the next board meeting. Well, he hasn't signed the contract, so the board can rescind it. Now, let's say that he knows darn well that they need to have that F-150 so that they have a brush truck to fight fires out in the western part of the county. He might sign that contract the next day, in which case then the motion to rescind would not be in order. Was that clear as mud?
I mean, this is actually pretty interesting.
You do need to take minutes of meetings of the BZA. There are some public bodies that don't need to take minutes, but you guys do.
And with regards to the minutes, if you don't post the minutes on the board docs prior to the meeting, that's not a FOIA violation, is it?
It's not, although you do need to post them within 7 days after they're approved.
Yeah, also on approval, because having gone through lots of minutes lately, looking for various things, whatever, do the minutes, number one, how do they transgress from draft to, is that just with the vote on the minutes, then they become,
When you vote to approve the minutes, usually at the next meeting, or if they're particularly long, it might take you 2 months to type them up, then that's when they're filed.
okay, but in because we haven't been doing it, but that's because I was looking at recent minutes or whatever, is that we haven't been signing, there's been no one is signing off on the minutes.
Yeah, you should do that.
And that's required? Okay.
I don't know that you need to sign the minutes, but somebody needs to approve
Or
it to
test
keep
them
the
or-
official
or
record.
whatever?
Yeah.
Okay.
What I did when I was the secretary was I sent the final minutes to the county administrator. So it said approved minutes of the BZA, approved at whatever meeting it was.
So you send them after the approval, not
Yeah.
before, not.
Well, what I was referring to is that when the minutes are made up, at the bottom, there is that information there that where the signature goes, you know. So basically the date they were approved and the signature, because that, you know, a lot of, I mean, I've been on lots of boards where, you know, minutes are minutes and nobody signs off on them, and
There's no requirement.
when I ended up in this job and I'm looking at the old minutes and there was nothing on there, I didn't realize that they were supposed to be signed off on until I started looking at other minutes and then went, oh, so.
It just, having a sign off at the bottom of the minutes does give an indication to somebody
That they
10
were
years
approved.
down the road that, oh, these were the approved minutes
Right.
as opposed to the draft.
Right.
But it's not legally, there's no legal requirement to
Oh,
do that.
okay.
It's not as though it makes the minutes invalid that somebody didn't
No.
do that, it's just, it
There's
makes
not a
it
minute
clear.
jail or anything, or if your minutes are not correct.
There's not
go
a
to
minute
minutes
jail.
And there's, minutes must be in text.
Yes.
I mean, we have ostensibly more accurate minutes than text with us.
But the text minutes are authoritative.
Well, I mean, the picture's authoritative, I mean, how we,
Not-
I mean, the texts are the opinion or the interpretation of the person writing it, there's no interpretation here.
It's not an interpretation anymore once all 5 of you vote yes on it.
I see, okay,
That's what happened, even if it didn't happen that way exactly.
okay.
I used to work for a county, and their board of supervisors did not televise and did not take an audio tape. The deputy clerk, the county administrator's secretary, she had originally trained many moons ago as a verbatim shorthand transcriptionist. So she would create the minutes, and there was no audio record, there was no other record, and once she created the minutes, she would trash her notes, because they're no longer administratively necessary, so Public Records Act lets you get rid of them. So the only authoritative record of the meeting was the minutes that she drew. And we would joke that, your memories are fallible, her name was Fain, Ms. Fain's minutes are authoritative. And always remember to have meetings in an ADA accessible space. Actually, surprisingly important,
Definite problem.
surprisingly important.
That's why we're meeting here today. We meet the requirement here.
You guys know that there's special notice for special meetings. If you're acting on an SUP or wherever else where there's a public hearing, there are special notice requirements. If you don't do the notice and I'm not gonna belabor those because you guys know them, but if it isn't done right, the action never legally happened. I've never seen anybody get in trouble for having too much notice, but I've seen people get into trouble for having too little. So when in doubt, throw in the extra sentence. It's not gonna hurt anybody, it's gonna cost a few dollars to the newspaper, but a lot less dollars than having to redo the whole thing because somebody gets snippy about it, goes to circuit court and decides and gets it overturned.
So you're saying we should really pretty much have 2 weeks' notice for everything, regardless of what the 3 days says, it just proves.
3 days notice just to get together and talk about anything. If
Right.
you're gonna be taking any type of, most types of substantive action that a BZA is ever gonna take, you need to advertise for 2 weeks.
Okay, what about information in legal notices? Does it have to be accurate? Or exactly what is required in a legal notice?
That is changing, and it depends on what it is. I did not print off 15.2.2204 before I came over here. Code section 15.2.2204 tells you all of that information. Although it is changing, it is becoming simpler as of this year. So pay attention to that. If you want me to, I can email that information out to you after the meeting. Who can talk at a public hearing? Well, for First Amendment purposes, a public hearing is a limited public forum, which means people have the right to talk, but only about specified topics for specified periods of time. And under control of the chair and bylaws. This seems very common sense to me, but you wind up in very strange situations when you actually get out there and start doing it. Generally speaking, my advice to you is, even if somebody lies, let them talk. If somebody starts cursing, let them talk. It's only if somebody basically goes over their time and starts completely getting, if you have a 3-minute time period for people to speak, after they get to 3.5 minutes, you kind of need to shut them down. But it is far easier for you to listen to somebody be a fool for 3 minutes than it is for me to sit with you for 3 hours in a deposition months down the road explaining why you didn't. You are not paid enough for that. However, if a person does get belligerent, the normal rule of if a person gets belligerent, refuses to sit down.
What if they're totally off subject also?
Well, you can usually going to tell them, can we please get back to, we're here to talk about this zoning application. Do you have anything to say that's relevant to that? If a person gets belligerent and you have a deputy sheriff in the room, typically what you're going to do is you're going to say to them 3 times, please sit down. After that, you say to them 3 times, you must leave. If you have done that, then the deputy sheriff can come up and show them the door. By asking them those 3 times, you are giving them plenty of opportunity to act in an orderly way, while also to stop being a jerk, while at the same time respecting their First Amendment right to speak. Closed sessions, you guys are familiar with those. They're the exception, not the rule. Although you can have one at any point in a meeting if you absolutely have to. They can even be impromptu. Whenever you go in, you have to give the reason for the closed session, the subject matter, and the statutory exemption. And I wrote down an example of of a Board of Supervisors potential motion. I move to go into closed session to discuss acquisition or disposition of real estate. Okay, so that's the topic. The subject matter is real estate in the town of Washington. Okay, so you haven't given away exactly what property it is, but you've given the public some idea of where the property might be. Where discussion in open session would adversely affect the bargaining position or negotiating strategy of the county. And then finally, the statutory exemption pursuant to Virginia Code section 2.23711 subsection A3. You need to give all 3 things.
So if you're the chairman, you should have that tattooed on your
Yes,
arm here.
you should.
At least that's on the inside of your glasses on the edge.
The most common ones, to discuss personnel, obviously not much of an issue for you. To consult with legal counsel. Economic development, again, not very relevant to you. Contracts, or acquisition or sale of real estate. Those are really the most common ones that I see in my normal life. For you guys, the most common one is going to be consultation with legal counsel.
Well, about we're allowed to have a note taker and a FOIA officer that's not of the board, so that would be a personnel.
It could be a personnel.
That we would be required to deal with in the but I'm not sure that we're even qualified or legally able to employ people. I mean, I'm not sure that.
You are actually.
Oh, we are.
You are statutorily allowed to employ or designate people if you have the budget to do it.
Okay, so
We have
what we
a
have to do is petition for the budget.
No, we have it.
You have a
Well,
budget.
but not that much money.
Everything is relative.
Yeah.
I mean, you know, to hire
We're running out of
a
time.
FOIA officer,
Yeah,
and
you
hire
gotta-
somebody to do all
Just kind of-
the
Well,
seeking of all the adjoining property.
Another question,
Um,
just a quick question on the closed
No.
sessions, is in, let's limit the private conversations. At what point in a meeting, in a closed meeting, when you go off topic, does that require that you go back into open session, and that you go in for legal discussion, and you come out talking about something entirely different?
At the end of the meeting, you're going to need to go on record by a roll call vote that only public business matters lawfully exempted from the open meeting requirements, and only the public business matters that you identified in the motion to go into closed session were discussed, heard, or considered. Don't put yourself in the position of telling a lie.
They're well aware of that, Rappahannock.
Finally, enforcement. Enforcement is by citizen lawsuit. Typically speaking, all a judge can do to you for a FOIA violation is order you to produce the documents, slap you on the hand for violating closed session rules, although there is a $1,000 fine against the body if you willfully and knowingly violate closed session rules. So if you have a close call where you got it wrong, the judge is just going to yell at you. If you have a close call where everybody in the world told you you were doing it wrong and you probably should have known, the judge might, well, fine you $1,000. That's pretty much the size of it. I am going to switch over to substantive legal issues. And I
have a question, just before we leave that particular subject. You supplied the link, and somehow somewhere in that link, I on my computer, I could probably look it up, but it'd take a while. It referred to a $500 fine for a FOIA violation for the first one, and up to $2,000 after. What was that talking about?
That is for violations that are willful and knowing. If you're in a gray area and you make a bad call, the judge is gonna yell at you. If you do something after having been told by an opinion of the FOIA counsel or something that that's not what you should do, you might get yourself into trouble.
Well, see, we recently had a case where the advice from the zoning administrator, from the powers that be, was contrary to what we decided.
And
Where are we? I
If it's-
mean,
if
we've been told.
you've been
But
told.
we were told by a number of people. I chose to go make my decision based on what our Goff said, and not what the zoning administrator asked, or the planning commission asked, or anything like that. But I mean, it was based on something, but the point is,
That sounds like you're making a tough call in a gray area. If Art said one thing and Michelle Summers said a different thing and you don't know what the right answer is and you pick a course,
yeah.
that's a gray area.
Okay, so I get to do, but if they all were in concert and we decided to go against it anyway, then we would be subject to $1,000 fine
You
or
might be.
500 or two.
No, wait a minute. In regards to what are you talking
Well, I
about?
don't know
Their
yet.
opinions or requests for information?
Can we move on? We're
All
really-
right, let's just
Well,
move on.
What do you?
I mean, I said we're running out of time, we've got a
No.
whole.
No, this is a relative question that I think we need to get to the bottom of. In that, are you referring to the decision that we made,
I'm
or are you
referring to the
referring
decision,
to a
I'm
request for
referring,
information?
no, I'm
Because
referring-
they're
I'm
different.
referring exclusively to the decision we made, because it was very controversial, and pretty much, as far as I could see, we were out on a limb ourselves with virtually everybody in the county, we were advised to the contrary
okay, we did what we did, but it was not without foundation or basis, but we still were told, don't do it, and we did it anyway. Now, what are we liable for here?
Well, you can always ask for, this is why the Freedom of Information Advisory Council exists. This is why a county attorney exists. That's why you have me on an on-call contract. All of these different people can answer these questions for you, or at least give you some guidance, and if you follow it, though, again,
We're safe.
nobody knows what a judge is gonna do on any given day, but if a judge does ding you, the judge is gonna say, bad boy, because you followed advice. Nobody expects you to be an expert, and they expect you to do the best you can as a citizen who's effectively a volunteer.
Right, not particularly legally, savvy or trained.
And also, what you're referring to or whatever, is that in the situation you're talking about, that's an ex parte situation. And so there's not supposed to be that influencing information basically going back and forth anyways, unless it's also being shared with the applicant.
That's part of the
And that's
next
part of the next
presentation.
thing, so.
Yeah.
Okay, all right.
So I'm gonna skip over some of the very basics, but I do wanna touch on this slide, I think it's the third slide, that talks about the basic nature of the Board of Zoning Appeals. You have some functions that are quasi-judicial, such as appeals of zoning administrative determinations or variances. And you have some decisions that are legislative, such as issuance of a special permit or an SUP.
Yeah, how is that legislative?
Yeah, really.
You have an ordinance, and then you have to make findings regarding whether or not it meets a general standard. You're not writing the ordinance.
You're not writing the standards.
The cheeky answer is because the Supreme Court of
Yeah,
Virginia
that's
told
what I
you that it was
thought.
legislative.
Yeah, it just seems arbitrary.
The more theoretical way of looking at it is, generally, a quasi-judicial decision is a decision that is, or administrative or ministerial, or however you want to call it, is a decision where there are criteria. If you meet X, Y, Z, A, B, and C, you get it. If you don't meet any of those, you don't get it.
Right,
That's usually a quasi-judicial type decision. And
right.
if you have to balance factors, like let's say you get a special use permit, but you shall consider in crafting the conditions on a special use permit, the comprehensive plan and the effect on the water and the effect on transportation. You have all these things you need to balance and kind of think about, and you're writing the conditions. That's why the Supreme Court sees that as being legislative. Being legislative involves the balancing of factors. Being quasi-judicial involves the meeting of elements.
Although the elements do exactly what you're talking about, anyway.
I understand that they
It's
shade
just-
over into each other in the middle. I'm just telling you the theory.
Yeah, okay, I got it.
Thank you
It
very
just
much.
seems totally insane. Just doesn't make any sense. Anyway.
Obviously, as a practical matter, you're appointed by the circuit court. You are answerable to the circuit court. You can be removed by the circuit court for cause. That once almost happened to one of your members. Ron remembers that.
What was that?
Yeah, you can talk about it later.
One-on-one.
Yeah.
All right, something.
Some local governing bodies, boards of supervisors, they make recommendations. I know that most localities that I'm familiar with, they ask for recommendations because a lot of times it's actually difficult to chase down volunteers for the BZA, and the judge says, I want the board of supervisors to go figure out who in their district is interested in doing this. I'm not gonna go chase people down. I got cases to decide. But some judges say, I don't wanna hear it from you. I'm going to decide who it's gonna be, and they'll advertise themselves and take applications and do interviews. It varies. Do whatever your circuit court judge wants, is my general advice.
And here, no, it's 5. It's it's not a single decision anymore, all five of them have to sign off on it.
Now, I understand the standard, the bar for whether something we do is actionable legally is whether or not it's debatable. I mean, I read that someplace.
It varies, and I'll get to that.
Okay.
Your basic powers, hear appeals of decisions of administrative officials, typically the zoning administrator, but not always. Grant variances, determine zoning district boundaries in matters of dispute. Grant special permits if authorized by the zoning ordinance or general law. Revoke special permits, you can do that if there are violations or if they haven't been exercised in forever or whatever. Make vested rights determinations and adopt rules of procedure. Those are pretty much the only things that you can do.
Rights determinations. Okay, good. We're gonna need that.
Your limitations. You may not rezone property. You may not decide whether the provisions of the zoning ordinance are wise. That's not to say you can't say we think that this rule is stupid, but we still need to decide the way that we need to decide. But you cannot change the rule just because you think it was stupid. You may not rule on the constitutionality of the zoning ordinance or the general zoning laws. So you can't say, well, we think that this rule is unconstitutional. That's a decision that only a court can make. However, you may look at it and make the decision that interpreting this rule one particular way might be unconstitutional, so we're going to interpret it this other way. You can do that. I understand that that's a fine distinction, but one is when you're interpreting a rule, one is saying the rule is illegal. You can't say the rule is illegal, but you can interpret the rule. If one way is going to mean that somebody can't do anything at all with their property, let's say, which would mean that their property is taken in violation of the Fifth Amendment takings clause. You say, well, we're going to interpret it this other way that means that you can build a single-family home on it so you can do something with your property.
But what
You
if-
might
I
go
mean,
with that
not-
second interpretation.
like, there are properties that you cannot build on.
Mhm.
So,
That's what variances are for.
But nobody
But
can
I mean,
demand that they
there
build on
may-
a property that they can't build on. They can't
Right.
just say, this is a limitation that other people don't have because their properties are bigger, so we should get an exception.
Hardship.
Well, but and certain properties can be declared as unbuildable, correct?
And there are some properties that the whole thing is in a floodway. There are some
Right.
properties, there's lots of
Been there, done
yeah, we
situations,
did.
yeah, where you might wind up with a piece of property that's unbuildable for all sorts of practical reasons. You have a property that's shaped like a bow tie such that there's no place that you can actually put a building on it. Well, sorry. But,
Well, plus, and it also, in, this is a situation that we have here, is that it was in, the flood, you know, the tributary for the Rappahannock River or whatever, that ran right through the middle of this property. But that's also federally controlled by the Corps of Engineers, and does that,
federal permitting is not your problem.
no, but we have to take that into consideration.
You might.
That trumps local ordinance, right?
Yes, it does.
Yeah.
Appeals from the Board of Supervisors go to circuit court, not to you. Some people get confused about that. And you cannot rule on subdivision issues, many site plan issues. You can rule on some site plan issues, it varies. You can't rule on stormwater, erosion and sediment control, or building code. There are different people who can rule on all of those things, not you. You guys rule on the zoning ordinance. That is where you live. I'm going to go through each major kind of decision that you make. Hearing appeals from decisions of administrative officers. It is quasi-judicial, but notice it's quasi-judicial, not judicial. If the General Assembly had wanted somebody with a black robe on to decide these issues, they would have created a court to do it or sent it to General District Court. They understand that you guys are citizens who are doing the best you can to follow the legal rules and that you are going to apply common sense in the spirit of the zoning ordinance to achieve a good result, rather than follow the strict rules that a judge might. You do need to have a public meeting, you do need to have a public hearing. The procedure is usually odd, okay? The administrative officer, usually the zoning administrator, actually goes first, even though they're the person who would normally go second that you would think of. They actually go first to explain their decision, then the person appealing it goes, then you have the public hearing, then you may call back either the zoning administrator or the appellant to answer questions if you want to. You do need to make a final decision. The decision should have the reasons stated, whether you want to have that be formal findings of fact and conclusions of law. It doesn't need to be that detailed, but it needs to be set up in such a way that a court could look at it and say, oh, I see why they made this decision. Again, nobody expects you to be a judge. They just expect you to be able to state reasons why you decided what you did.
And also, it's equal time for everybody on appeals. You
Yes.
can't set a time limit on the general public and let the applicant and the.
I know that the general thing that I have seen is that usually for an example, it would be something like the zoning administrator gets to argue for 20 minutes, the appellant gets to argue for 20 minutes, then there's 3 or 4 minutes for each member of the public to talk at the public hearing, and then at the end, the zoning administrator and appellant may be called back up by the board to answer questions, and you guys can just ask the questions for as long as you feel you need to.
Okay, so basically on the public comment portion, then you can't, because my understanding was that on appeals, that you couldn't do that, that you had, if the neighbor wanted to get up and talk for 20 minutes about the decision, they had standing, so that you had to permit them to do that.
If they want to do that, if you want to do that, and I have seen that done, typically they're going to pop their head up and file something with you so that you know that they plan to act as a party, not as just an interested member of the public making a comment. Now, the fact that they haven't intervened doesn't mean they can't appeal to circuit court. It just makes a difference in terms of how you're going to treat them at the public hearing.
Okay.
Do we have any actual time limit on public comments, like the 3 minutes?
Yeah, that's what I'm
Yeah.
referring to, because I believe in
We
our
usually
rules
do.
and procedures, that's what we have under appeals, is that you have to give equal time to everybody, as far as asking a question.
And typically, according to Robert's rules, you have to give everybody a chance to do it once before you give anyone a second chance.
No, I understand that. I was really thinking about the time. You probably want to amend that, right?
Well, we're gonna, we're gonna amend our rules and procedures, but we're gonna wait until after May 1st, because there'll be
Right.
lots of things that we have to take out anyway,
Yeah.
so.
Variances, the original purpose of a variance was to be an outlet valve. So let's say that the zoning ordinance doesn't allow you to do anything with your property. The purpose of a variance originally was to allow you to do something so that the zoning ordinance did not affect the regulatory taking of your property. Today, it's a little bit more loose than that. It is administrative or quasi-judicial in nature. That's because you have 5 elements that the person needs to show. The property was acquired in good faith and the hardship was not created by the landowner. And there's conflicting case law on whether the person before can have created it. It's conflicting. You get to that in individual cases if
Due
necessary.
diligence.
Could matter. The variance would not be a substantial detriment to surrounding properties. So basically, you're not going to ruin the neighborhood by giving the variance. The condition is not of so general or recurring in nature that it would make more sense for the Board of Supervisors to change the rules. The variance does not allow a use not permitted by the underlying zoning. So you can't, if it's in an industrial district where residential is not permitted, you can't allow them to do residential. You might make it easier for them to build, let's say, a woodworking shop there that otherwise would be a use that's permitted, but you can't allow a use that's otherwise not allowed. And the relief is not otherwise available through a special exception or CUP or special permit or similar process. There are some special provisions dealing with situations where a person needs a variance in order to get an ADA accommodation. Basically, you should grant those, although they should be conditioned on ceasing when the person's disability need ends. You can put conditions on variances. So that's an important thing, and they are similar to special permits in that respect, that you can put conditions on. And this is more the standard thought process. Applicant makes the presentation, county staff makes a presentation, public hearing, and then you guys can ask questions or make the decision.
Okay, on variances also, because I think the last one we did, that we actually passed on or whatever, and it's come up down. Part of the conditions on the variance was the height of the structure.
Yep.
Is that permitted, because basically what's happening is that the variance was granted so that they could sell the property, so there'd be a reasonable house site on it. And now the property is, someone's looking at buying the property, but the condition that the variance was granted under was that it needed to look like the house next door, which was a one-story house. And now the person is coming in, they actually want to reduce the footprint on the house, but they wanted to go 2 stories. And that's,
Sounds like
should those kinds of things be put in variances? I mean, variances are normally setback related to a great extent, but other than going beyond the maximum height to reduce the number of stories or whatever, to me, doesn't make any sense. And the other thing is, how can you correct that? Can you get a variance on a variance, or can you go back and go once a variance is passed?
A person would reapply for a variance, and then the variance could be removed.
Or
amended.
or modified?
Rescinded or something.
Yeah. Could be amended.
Okay. You need to know that.
You won't very often have to deal with setting boundaries. Back in the day when they used to use back in the day when they used to set zoning boundaries with a colored pencil.
That's what we have.
The actual mark on the page is like 100 feet.
No,
across.
we're not talking pencil, we're talking magic.
Magic marker.
Yeah, right, but I mean, we're talking 1/4 inch wide, on a scale that makes that 100 feet across.
So perhaps you do have to make those decisions. Now.
Well,
This is
what-
Rappahannock.
Yeah, this is, yeah, but the regulations say, I think, if I'm not mistaken, that the districts are supposed to follow property lines.
There are rules for it, yeah.
Right, but they don't always, and this is where we come in, and this is one of the things I muse about in my personal writings, is how do you resolve something like that? Do you say that the person who owns a property, if it's below a certain size and it's divided up into 3 districts, they can pick what district they want?
No, you would take a map of the property and try to draw it.
So in a case like that.
You can have a split zone property.
Oh, right,
But
but
also
that's not what the
we would get-
guidelines for the district requirements say. They say it should follow the property lines.
If possible.
Yeah, right, I
Practically
mean,
every
it's not-
property
How could it be impossible?
in this county over a certain acreage is gonna have conservation
That's why I
and
said,
agriculture.
below a certain acreage, becomes an issue, because you need a certain amount. I think one of the places we did was quite a very small property, and it had a number, at least 2, maybe 3 districts in it, and I mean, like, the property was so small that none of the single districts would have allowed for a building.
It was, yes, we had one in Browntown where it was a 2-acre lot. It was split between agricultural and conservation. And then they were trying to put a house site on it, but the setbacks are different. And on that, we worked it out, but it would seem to me that on a 2-acre lot, you would just pick one and go around
That's what I'm
the
saying.
edge of the property and make it all one. That's the logical way to deal with it.
Yeah, well, that's one of the things I'm using about it.
One of the very first engagements that I had as a young lawyer was to help the city of Petersburg redraft their zoning ordinance, which had not been touched since the 1970s at that time. I've only been in practice almost 20 years, so at that point, that zoning ordinance was a good 30 years old. Without being touched, not a single amendment. And so I asked, well, can you give me a copy? Do you have an electronic copy of the zoning map? I'm sitting there with the planning director, and he yells to the secretary, "Go grab the zoning map!" There was only one.
How many do we have, Michelle? Zoning map?
At least one,
I
right?
mean, in total, there are sections of it or
Yeah.
whatever, but in total, I mean,
And there had been rezonings during that time, and they were all just like done in marker. And so I was like, oh no! Their zoning ordinance is much better. Special permits, the basic concept here, and I'm just gonna quote the case, which is
you go over this quickly.
Yeah,
I
we don't have
understand
it
that you guys
anymore.
gotta do what you gotta do,
So we
but,
also don't have it in the
oh, okay.
Well, we actually would still do it.
Then I'm gonna go through this super quick. The basic concept is that the legislature may require certain uses, which would be you, which it considers to have a potentially greater impact upon neighboring properties or the public than those permitted in the district as a matter of right to undergo the special use permit process. Each site is to be examined by public officials, guided by standards set forth in the ordinance for the impact the use will have if carried out on that site. Although the uses in such special categories are permissible under the ordinance, such permission is to be granted subject to such limitations and conditions as public officials may impose in order to reduce the impact of the use upon neighboring properties and the public to the level which would be caused by those uses permitted as a matter of right. So, that's the general concept of what you're trying to do. The conditions are imposed, they're not voluntary. It's great if the applicant agrees to them. Applicant doesn't need to agree to them. It's ultimately up to you what the conditions will be. As you were saying, Bill, the conditions have to be reasonable. They're considered to be reasonable if they're fairly debatable. That doesn't mean that you were right. The court isn't going to say, oh, I agree, that was exactly what they should have done. The court is going to say, well, yeah, I can see that where a smart person would say that. If you can get to that, you win the case. That's the fairly debatable standard. Conditions are subject to what's called the Nolan-Dolan test under federal law. So they have to have an essential nexus with the harm you're trying to mitigate and be roughly proportional to the scope of the harm. And I could go through those cases, but probably not necessary. Here's a little interesting quirk though. If the Board of Supervisors issues an SUP, they don't need to give reasons. If you issue an SUP, you do. Very strange, but that's how it works.
Oh, so they don't, you're talking about findings then, right?
Right.
Ah, okay.
You might have to give findings. The Board of Supervisors can just be like, yes. Okay.
Okay. But they also say no, and you don't need reasons either, right?
Right. Well, I apologize that we've only got 10 minutes left, but I'm going to try to go through vested rights because that is an important aspect here. There's basically three kinds of vested rights. One is a lawful non-conforming use, another is a grandfathered use, and the final is a vested right. There's also what I like to call the closed book rule, and I'll get to why you have those kind of 4 rules that come into play. So a lawful non-conforming use is something that somebody's been doing ever since Jesus wore short pants, and so they get to keep doing it as long as they don't expand the use or discontinue it for more than 2 years. That's the basic rule of lawful non-conforming use. Or, they started doing it 5 years ago, and then 2 years ago, the Board of Supervisors took that use off the list in that zoning category. Again, as long as they keep doing what they're doing, they get to keep doing what they're doing.
What about confusion on expansion? Because there, particularly when you have a storage facility or area or whatever that is non-conforming use or grandfathered or whatever, can that, it's within the property itself, can it expand out, or is that pretty much locked into where items are sort of in storage now?
The case law is very complicated, and the local ordinances also sometimes expand. The cases and statutes set a bare minimum of vested right. You can give non-conforming use ability to expand within the same building and things. But some ordinances give people more rights, which is the next thing, which is a grandfather use. That's when somebody is given the right to do something as a matter of grandfathering or as a matter of legislative gratuity rather than having a lawful non-conforming use where they have a right to continue what they're doing. And I'll give an example. It's not unusual for a board of supervisors to say, we're going to make it so that in A1 districts, it's 5 acre minimum lot size rather than 3 acre. Let's say that they make that rule. But everybody who has a subdivision plat that has currently been filed will be permitted to have that subdivision plat approved under the 3 acre zoning, assuming that they diligently pursue it and it's completed by the end of the year. They don't have to do that. They can chuck out all those subdivision plats because the law changed, your subdivision plat's dead, get out the door. But a lot of times the board will let people who are partway through that subdivision process finish it up. The next one is a vested right. It's when you're partway down, a developer's partway down the path, but hasn't yet gotten all of their approvals up to a building permit and CO. So they're allowed to continue down the path because they've gotten far enough, they've expended funds on it. As long as they keep pushing forward diligently, they get to finish it up. And finally, the closed book. Sometimes when an administrative officer makes a determination, they can't take it back even if they were wrong.
Does that need to be, the determination need to be written? If you're relying on something that's, say, 30 years old and it was verbal, is it those done by an administrative officer, or is that?
It's usually, it's a written determination.
No,
However,
it's a verbal. Gotta remember.
that a purely oral determination isn't going to do it, although you may take somebody's testimony that there used to be a written determination, if you believe it.
Well, there may be a case where there's no, for instance, if you're asking whether or not a use it needs to be permitted and you're told that no, it does not, then that's not gonna be written, right?
Right.
But the
So,
thing is,
is the determination not binding?
if you were to find that the situation that she just described repeatedly, where the permission was given repeatedly, and you could have like 3 or 4 businesses testify to the fact that they were told they didn't need a permit, then would that be as good as having this?
I would say that that's not probably a vested rights or a closed book issue. What you have right there is a discrimination and arbitrary enforcement issue, which can be a different kind of issue, but that's just a different kind of issue, and you might decide that that there are individuals, you could in that particular situation decide that there are particular individuals who are being targeted based upon previous approvals, based upon, you might, so let's say that all of you are running the same kind of business.
Right.
You got a zoning permit 30 years ago, you got a zoning permit for 25, you got a zoning permit for 20, you got a zoning permit for 15, the good doctor decides he wants to start it today. You guys have all been doing, have all gotten a written zoning permit, which tells you that it was a permitted use at the time that you got that, right? So you know that that's the rule. Second thing that you know is that nobody went after any of you for doing that particular use. Which means that if they go after him for that particular use or refuse to give him a zoning permit, there could be a discrimination or arbitrary enforcement issue, and you might take that into account. As you guys, it's all closed books on you four. You guys are all subject to the closed book rule. The book is closed. But it's being.
Deny him, that would be arbitrary.
At a certain point, if you've gotten all of that, and it's clear that you guys were it was at least a reasonable, a fairly debatable interpretation for you guys to get the permits that you got at the times that you got them, it could be an arbitrary and discriminatory enforcement as to him. Does that make sense?
And the
Sort of,
reverse would be true, if you didn't get a zoning permit?
because there is no, if you got a permit, you got a piece of paper. If you went in and they said you didn't need a permit, you got nothing,
Right.
and you walked out of the office.
I think it depends, would this be a use that required a site plan?
No.
No, it's,
That creates an issue.
it's what, we all know what we're talking about here.
Yeah.
And, you know, that was the situation, is that, you know, individuals went in and they asked whether they needed a permit, and they were told no. And so they went ahead and did what they did. And, then, under the same zoning ordinance, a third person comes in and asks, and they are told, no, you have to have a permit.
Now, that's arbitrary, right?
In that situation, like I said, you could have an arbitrary.
And that's
discriminatory
it's
enforcement.
going in the other direction, but that, yeah, okay.
There's several types of grandfathering. If a structure has a building permit and a CO, and the person's been paying taxes on it for 15 years, they get to keep doing it. If it didn't require a building permit or a CO, the statement of an authorized local government official, including a verbal one, is sufficient to make it lawfully non-conforming. You can always alter a lawfully non-conforming building to make it less non-conforming without bringing it fully into conformity.
I want to ask a question about the grandfathering thing. There's and this is completely outside our purview because it's a town thing in Wood County. But down the street, we have a junkyard equipment facility, and it's been generational. I mean, the fellow's father had it before. But from my understanding, it was a far smaller operation. Now, does grandfathering mean that you can, just because you had this business, you can expand it within that property as much as you want? Or are you limited to what was grandfathered?
Generally speaking, you're limited to continuing the use at the same intensity.
Right.
Now, ordinances can give a person the right to expand if it wants to. You can put that into your zoning ordinance.
Right.
And I don't wanna say that I know anything about the town of Little Washington
So
zoning.
we don't make the zoning ordinances.
But general rule is that you can't expand. Although one of the issues that you always have with junkyards, or auto salvage yards, or whatever you wanna call them,
Recycling centers.
automobile graveyards is another one I've heard, is proving what the scope of the use was 30 years ago. Unless you happen to have an aerial photograph or something from 30 years ago, it's really difficult.
We do have aerial photographs of everything from 30 years ago out here, actually.
But
They're kept by the state, but we have those. In fact, for certain things that are required for certain applications.
so sometimes you have them and sometimes you don't. So periods. I had one down in the far wilds of Southwest where there wasn't aerial photographs, and somebody was like, well, I know that that's expanded. How much? I don't know. Sounds like you're probably right. There are cars that are newer than whatever year.
Start looking at vehicle numbers and whatever, yeah, that's
Vested right is really the most difficult of these to apply. You have to have three elements. Landowner has obtained or been the beneficiary of a significant affirmative governmental act, we call it a saga. They rely in good faith on the saga, and they have incurred extensive obligations or expenses in diligent pursuit of the specific project. I've given you a list of what the normal sagas are. Now, this last point is a point where vested rights only carry you as far as your approvals carry you. That is actually a point that is in dispute. I thought that that was the law when I wrote this, and then I was retained by a county that is currently fighting over that point in circuit court to help their county attorney with parts of that litigation. So apparently somebody's now arguing that it wasn't right. But the way that I think that the rule is probably ultimately going to be, and this is something that Judge Horn up in Loudoun County said one day. Somebody came in with a health department permit for a septic tank, and in order to build the building that they wanted to build, they needed a site plan. The zoning had changed so that they couldn't build what they wanted. All they had was the health department permit. So they came in and said, the health department permit gives me a vested right. Judge Horn said, gives you a vested right to a drain field, doesn't give you a vested right to build that building.
How quickly does that, I mean, because there are times when, particularly with real estate deals that are based on permitting and whatever, you know, the permit's issued and you sign the paper and you're suddenly obligated with a contract, and then for some reason it changes, you know, the ruling or whatever, how does that work out? Particularly if it was like, if it was challenged in court or something.
Well, one of the ways that you can get a vested right is by getting a vested rights determination, which means that you ask the zoning administrator, I want to do X, Y, and Z with my property. Is that a lawful use? And the zoning administrator can respond, and it's about whether that's a lawful use, and typically the zoning administrator will say, you know, this is limited to the facts that you presented and may be subject to change if there is a change to the zoning ordinance. But as long as there isn't a change to the zoning ordinance, you can get financing on that. When you go and you submit your site plan or your subdivision plat or whatever, then you tack that letter to the back of your application. You hand that to the zoning administrator or the subdivision agent. Then they know what the situation is, they go and they approve it. So you're moving diligently down the path to get approved, following each step. And as long as you're doing that, you're going to tend to have a vested right.
Yeah,
Now, there might be, there's always some way that you might step into a bucket that you didn't see there.
yeah.
Because lawyers are clever, especially
You
when
guys
they're
in
being
business.
paid to be clever. But that's the general way that it's going to work.
We've had people come in who have purchased properties that really, if they had done their due diligence, they probably wouldn't have done it because they weren't able to do what they wanted to do, but in good faith, they bought it thinking they were gonna be able to do what they were gonna do, but, and does this mean because it was a good faith purchase on their part that we have to let them do what they thought they were gonna do?
That's one of three elements. The first is that they acquired the property in good faith and are pursuing it in good faith. The second is that they have some type of approval that lets them start off with the project, like a special use permit or a site plan or something. The third is that they have incurred expenses or obligations based upon the approval. So let's say that you have let's say that you bought a piece of property, you bought it in good faith, thinking that you would be able to put, your wood shop on that property. You decide you're gonna be a furniture maker, so you're gonna put a wood shop there. You go in and you file for a site plan, and you get your site plan. Then the zoning ordinance changes. So, well, let's say that you've got the site plan, you've signed a contract with a construction contractor to build you the building. Then the zoning ordinance changes and you can't do a wood shop in that district. Well, you are nevertheless going to be allowed to continue down the path to getting a building permit and then getting a CO for that building, assuming that you continue diligently doing so. So it's basically, you can't pull the rug out from under you if you've gotten partway down the path and spent a lot of money on it.
Right. I mean, just because you bought a thing in good faith.
That ain't enough.
That's not enough.
Going to kind of skip through a few things. Remember, appeal to circuit court is by writ of certiorari. The way the laws changed a few years back, you are no longer a party. And when it goes to circuit court, the only thing you do is you pull together the papers, you make a photocopy of them, and you send them to circuit court. You're done. That's all you do.
And that's the job of whom? Or we'll be discussing it later.
Now, the question I think that we can always have is, why would a BZA need a lawyer other than the county attorney? Now, on a quasi-judicial or administrative proceeding, the county attorney represents the county staff, and you might well find against county staff. So the ex parte rules and the ethics rules of the Virginia State Bar make clear that the county cannot advise the BZA on specific quasi-judicial matters before them. Interestingly, on a legislative proceeding, an SUP, the county attorney can advise you,
Yeah.
as comfortable and weird as that is.
Indeed.